There are several key participants in a criminal court event. There are two fundamental principles of the Canadian justice system. The accused person is innocent until proven guilty. Guilt must be proven beyond a reasonable doubt. Beyond a reasonable doubt is a standard of proof whereby the defendant's guilt must be proven to the extent that a reasonable person would have no choice but to conclude that the defendant did indeed commit the offense. The judge is the court official appointed to try cases in a court of law and to sentence the convicted persons. The judge makes decisions on things such as admissibility of evidence and interpretation of the law. In a jury trial, the judge is the trier of the law, and the jury is the trier of fact. The judge instructs the jury on points of law. The jury decides the verdict based on the judge's instructions and the evidence or facts presented, and the judge sentences the person. In a non-jury trial, the judge does both. A justice of the peace is a court official who has less authority than a judge, but can issue warrants and perform other judicial functions. The accused or defendant is the person charged with committing the criminal offense. The duty counsel refers to a lawyer on duty in a courtroom or police station to give free legal advice to the persons just arrested or brought before the court. Defense counsel is the lawyer who defends the accused person on trial. The Crown Attorney or prosecutor is the lawyer representing the government. They are responsible for bringing forward credible evidence of a crime. Evidence is information that tends to prove or disprove the elements of an offense. Court personnel include the court clerk, who assists the judge by keeping a record of the trial exhibits, administering oaths, and announcing the beginning or end of the court session. The court reporter records word for word everything said during the trial. If required, the reporter can produce a transcript or typed record of everything said in the court. The court security officer handles accused persons who are in custody and helps maintain the security in the courtroom. The sheriff is responsible for the jury, including summoning, paying, scheduling, and guarding them. The bailiff is a court official who assists the sheriff. Witnesses give evidence under oath or affirmation of their knowledge of the circumstances surrounding a crime. They are compelled to appear in court by a subpoena, a court order requiring the witnesses to appear in court on a certain date and to give evidence. Failure of a witness to appear can result in a contempt of court charge for obstructing the course of justice and disobeying the court's authority. Committing perjury, that is, knowingly making false statements in court while giving evidence, is a serious offense. The maximum penalty is 14 years in jail. The jury is a group of 12 people who decide whether the accused is guilty or not guilty. They are chosen by the Crown and defense from a pool of ordinary citizens. They listen to the trial, consider all the evidence, and follow the judge's instructions about the law. They withdraw to the jury room to deliberate, consider the evidence, and decide guilt or innocence. Their decision must be unanimous. The word jury comes from the French word jureur, which means to swear an oath. Eligible jurors are 18 years old, Canadian citizens, and a resident of the province for at least 1 year. Publicly elected politicians, lawyers, and prison guards, police officers, and probation officers cannot serve as jurors. People can be exempt from jury duty for health and religious reasons, financial hardship, or if they have served on a jury in the past 2 years. If you wish to be excused from the jury, you can apply to the sheriff.